Lords and ladies, I appear on behalf of the Secretary of State, I'm Miss Anderson, and my learned friend Mr. Broadfoot, KC, and Mr. O'Cayley appear on behalf of the respondent to this matter, an individual who I think we're anonymising as AI, or I am, anyway.
Yes.
Acceptable. This is Secretary of State's appeal. It's a cost matter, and I just do some housekeeping just to check. I think my first order of the day is an apology. I'm sorry you didn't get hard copy authorities bundles. I did ask them to be provided. I can't explain it on an error on my
Well, don't worry, because I think we're all, in fact, working electronically, so it doesn't matter on this occasion.
This as well.
It just means perhaps when we're looking electronically, it's just quite important that you give page numbers.
Absolutely, and as I say, I'm working electronically as well.
Great, so thank you.
And I'm a bit of an old dog when it comes to these things, so you might find I'm working at a steady pace rather than one of these young things that can do it by the wrist. So, in terms of housekeeping, 3 bundles: authoritative bundle, which is virtual, a core bundle, and a supplemental bundle. Hopefully, skeleton arguments are in your version of the core bundle, so there shouldn't be anything separate. The only floating document I think might be the cost schedule, but that may not arise anyway. So, hopefully all the documents should be in place. I'm proposing to take these quite quickly on the basis that I assume you've had an opportunity to consider the skeleton arguments. I'm going to set out my positive case for the grounds of appeal. I'm not going to deal with the reply points in opening, as it were, and I will leave those to reply to see the extent to which the court would want me to go over those issues, because it's one of those things where they could be potentially very large or they could be very short. So I think that's the most economical way of dealing with the reply points.
Well, you must take your own course, and we'll see how we go.
Thank you, my lord. You will see that there are 2 grounds of appeal, but they interrelate. So hopefully we should be able to take them together. The sort of headline point, I suppose, from my point of view, is that this is one of those cases, although normally in costs matters there's a reticence about an appeal court intervening in a cost matter. But I do say this is one of those cases where it's entirely appropriate. Indeed, given that there's a material error of law, I would say more than one, it's important that the court does intervene to clarify these principles that do seem to be causing a certain amount of confusion below, if that's the way of putting it. So that there are quite a series of these cases, not just related to the Dublin regulation point, and the effect of the withdrawal from the EU, but generally in relation to outcome and the extent to which outcome should lead to an award of costs against the Secretary of State, so penalising the Secretary of State.
Can you flesh that out for me at least? What other areas are we looking at a similar type of Dublin 3 situation? Or an academic, something becoming academic?
It's just the idea that, particularly in this immigration area, but generally where there's a public law decision maker, you make a decision and that's challenged, and that's often a sort of historic event, although of course there's an ongoing duty to make decisions.
I'm fully aware of that, but is there anything specific that you can identify for us beyond Dublin 3?
No, but you will see that what my learned friends are arguing for is a sort of general point that essentially outcomes, the event, should be taken in the broadest possible terms. That if you get in terms of a sort of event of achieving remaining in the UK in the broadest possible terms, then that can be seen as less in the litigation.
Okay, so you say important point of principle in the context of public law cases generally.
Yes.
Right.
And as I say, partly because of the nature of public law, because often the duty to make decisions is ongoing. So if there's a challenge to a historic decision, it may be that the Secretary of State, or whoever the decision maker is, not necessarily the Secretary of State, might make a decision with future consequences in a particular way, but that doesn't mean an acceptance that the historic decision was unlawful. And there is a confusion perhaps arising as to if you achieve that sort of future effect, that could be seen as succeeding in your challenge, even if your legal merits really have nothing to do with the future effect of some point that's either become academic or there's just some new information or new point. And there is this tendency, in my submission for a sort of rather simplistic approach to the words in test pay in particular that say, well, you can look at the outcome broadly, therefore, if you're in a better position than you were before.
It's not irrelevant to look at the broad outcome, is it? You can't say it's irrelevant.
It's absolutely not irrelevant, and that isn't my submission. It's just looking at it judicially and looking at it in terms of legal merits, legal relief. You know, what was this claim all about? Can you say you've succeeded in that claim in getting the relief? Because really, relief helps. Because relief isn't usually a sort of event in a sense. Relief is finding a decision unlawful. So if you've established unlawfulness or it's tolerably clear that you would have established unlawfulness, then you can see, of course, the fact you've achieved that earlier on rather than later down the line, that is a basis for positively awarding costs against the Secretary of State. But it's not a basis. It really all that's happened is that time has passed and new decisions have been made, and through that, the sort of ultimate event.
You also have to look at the proceedings very broadly, how they're conducted, and where we've got. What I have some difficulty about in this case is that there was a hearing before the Upper Tribunal on a preliminary issue in October 2020.
Yes.
Was anything said to the tribunal about the timing issues?
Well, I think everyone was aware of it, but I don't think anyone really envisaged that a judgment wouldn't be available by the relevant time.
By what time? Sorry, by.
Well, it would
31st
be the
of
end
December.
of December. Yeah.
But if you succeeded at that point, that still wouldn't have entitled you to remove. This is only a preliminary issue. So what did the government expect would happen?
Well, my lord, it was really difficult at those times because if one looks at all the options, I can't speak to many things, but it wasn't clear at all that there wouldn't be any successor provisions, there wouldn't be anything in place. If you are aware of the Dublin regulation, you'll see that it applies to non-EU states as well.
Yes.
There are circumstances where there are arrangements.
Well, this arises in a number of areas, and it arises in lots of issues generally, in commercial matters as well, service, etc. Big issues about that sort of thing. But there's no doubt that the government, better than anyone, knew that there was a risk that on the 31st of December that this matter would be over.
But my lord, I think that's still the principles. We'll come to it when I come to the argument. But
I'm just trying to understand what happened.
Yes, the principles are still
Did anyone write the tribunal or tell the tribunal that unless they produced their judgment quickly, there was a risk that it would become academic?
Well, my lord, this is an extremely experienced tribunal that was well aware of the situation.
Well, one wonders because they didn't produce a judgment.
Well, my lord, I can't speak to that. All I can say is it certainly wasn't a straightforward issue, as it were. And it may be that on the unfolding of it, it became more complex and difficult than was first envisaged. And it may be there was an agreement between the parties, the members of the panel. There's so many different factors that can play into it. Maybe some other things.
Sorry, forgive me. I just wanted to know simply, was anything said to the tribunal about the impending cliff edge?
There was an awareness of it, but it
What
wasn't.
what does that mean? I'm sorry.
Well, I can't say the tribunal were ignorant of it, and it wasn't an awareness of parties, but it wasn't a clear course as to what to do about it.
Was anything said to them, either at the hearing or subsequently?
No submissions were made to them that the tribunal should not carry on or make a decision. And indeed, it was said that this was an sort of point of principle for other cases because there were issues of interpretation. So it wasn't a purely case-specific matter. So it was seen that there was some value in it if a judgment was produced, as it were. But my lord, what was being alleged was unlawfulness in decisions, and the lawfulness or otherwise of past decisions have an impact or can have an impact. So the statute, the third country certification regime requires the Secretary of State to certify a certain. It's not a discretionary decision; it's a requirement to certify. And so to drop it, as it were, to sort of stop doing it, one has to have a positive sort of basis for doing that. And I appreciate the pragmatic situation, but in this instance, it just simply, as I say, one couldn't sort of drop in advance on the basis the tribunal might not be able to do it, unless the tribunal came out and said, no, we don't envisage this possible, in which case So rather than probe the tribunal to sort of say, you know, is this case possible or not?
I understand that. I'm just wondering, wouldn't it just not be normal to say to a tribunal in this case, when the hearing ends or afterwards, to say, by the way, tribunal no doubt be aware that as things stand on the 31st of December, this point will become academic if we haven't if it hasn't been resolved by then.
My Lord, I'm satisfied the tribunal were aware of that without the parties to indicate that. It was an obvious matter, as it were, and
but they still hadn't produced their judgment as of May 2021.
Well, I think that there was and the courts have allowed this time to look through all the cases. You know, one can't make instantaneous decisions and sort of deal with matters sort of instantaneously, and so there was time allowed to look through all the cases to consider what was appropriate, etc., and to deal with them in order.
I've just gone blank, and it's my fault. Could you just remind me who the Upper Tribunal judge was in October?
We're looking at, on costs, the decision of Upper Tribunal.
I know.
Judge Carr, but the.
I'm looking at the hearing.
Was the,
right.
The sort of,
he was the judge in October.
Yes. With Mr. O'Callaghan, obviously.
Yes.
So.
Right.
So Mr. Opperton, as you're probably aware,
yes.
is an extremely methodical person.
Yeah.
We would not consider that the sort of time frame of legislation is extremely methodical in looking at those sorts of matters. But as I say, it was a sort of a feature there, but there was no obvious course of action that anyone was pressing in response to it, because there really wasn't sort of clear-cut, obviously right thing to do, given that the legal issues were being raised and pressed.
I'm sorry, I may be taking this too far, and it may be unfair to you, but I'm trying to understand what did the government think was going to happen?
Well, I don't think I can speak to that, my Lord, in the sense of I think it was envisaged by everyone a decision would probably be made.
And then what?
Well, then we'd have clarity on those legal points. And as I say, it wasn't clear at all whether there'd be any successor provisions or something of that nature.
So, Samson, can we just follow through? If a decision had been made before the end of December 2020, either the government was out of time to return, in other words, the 6-month limit had been exceeded, and if that was right, that was the end of the government's third country case, wasn't it? That you'd have to have withdrawn the third country certificate. So that way there would have been a conclusive end to this litigation and the matter would have been decided domestically. But if the government won on time, all that did was mean that it was open then to look at the age assessment point. So that would have had to have been done. And that, if the government was still contending that he was an adult and so could be returned, in reality that would have depended on there being some sort of Dublin extension under the settlement at the end of the year.
Well, my lady, it depends. Of course that's right, and I can't argue with it. But what we're looking at is the challenge to the lawfulness of historic decisions.
Yeah, I understand
yes,
that.
there are those ongoing effects, and of course in the end, that
Yep.
is...
Yep.
But it is quite a thing to say we accept something as unlawful, or we're just conceding litigation, accepting it's unlawful, because that's the way it would have to be done before the...
I think we're slightly at cross purposes. I mean, I'm not making a point against you. I'm just trying to understand where we are. But I think where we've swum into, in fact, was precisely the point you didn't want to get into, which is answering their case, which is the delay point.
Yes.
So I was just trying to understand how that all unfolded and what the options would have been, certainly in October 2020. I think I have on board your prior argument, which is that you have to look at where a case is, let's say, where the Secretary of State withdraws a certificate, whether the withdrawal is because the original decision was unlawful, which you say can then lead to a costs order under the ordinary rules, or where it was just coincidental or for an extrinsic reason.
Some supervening events, some change of circumstance, something, as say a fluxion of time in some cases, because one has to bear in mind, and again I don't really want to anticipate the reply point, but there is case law that says even if the Secretary of State delays, so under the Dublin regulation there are sort of provisions about when you have to do things by and stopping the clock and so on and so forth. So if the Secretary of State doesn't do what should happen by a fluxion of time within the Dublin regulation, it's no longer possible to transfer back. that can be said to be, in some circumstances, Secretary of State's fault. You know, some notice should have been given, or some stay should have been extracted from the court, or something of that nature. And even in those circumstances, the case law says that costs can't be awarded against the Secretary of State. So it is important to be very precise about this, because it's not a situation where you are awarding costs against someone. I know it's the Secretary of State who's perhaps seen as you know, a different type of party, but in my submission it's still a positive order against someone, and you still need a positive basis for doing that. And so even if the Secretary of State made bad strategic decisions, or as I say in the case of allowing the doubling clock to run out, it doesn't mean that the original decision to certify was unlawful. And that really is what all this is ultimately, from a legal perspective, about. And although we set the legal proceedings in their practical context and their pragmatic context, my underlying submission is there is a limit to how far you can go with that, because the extrapolation of it is that people will then do things, bring unmeritorious claims, but claims that, because under the policies that there's an automatic stay, if you challenge in the High Court and you file a judicial review, or the tribunal, there will be an automatic stay under the policy of Part 60 of the Enforcement Instructions and Guidance. And so you can procure an obstruction by simply putting in a judicial review, even if that is then dismissed, as many are, as totally without merit. It has achieved its objective of stopping the legal decision, stopping the upholding of the law. And because of the delays that are created by that, you know, sort of being done by many, many, many people, as was envisaged in Carr, you can procure really quite a lot of delay, depending on how circumstances are. And so that is the danger, the sort of underlying. I don't want to do a floodgates argument, but I'm simply pointing out that the point at which you stop looking at the practical context and the outcomes, and it must be there, because one must always keep in mind the legal claim. You know, there must be an underlying meritorious legal claim that shows that the original decisions were unlawful. You know, that's the sound basis for awarding costs against the person who made that decision.
Thank you. I, for my part, am quite interested in the submission that you made, and I just want to really think about this hearing whether the public law context, where you've got an ongoing duty of review, and you may well have a sort of subsequent decision that changes the earlier decision without, you would say, without casting any, without characterising the earlier decision as unlawful. I'm just interested in whether that marks out these cases as in some way different from the mainstream of private law cases, or whether it's the, I think we're talking about the same rules. I think we're all on CPR 44, and it's the ordinary rule prevails. But I just want to pick away, and I want both of you just to keep an eye on whether the context of public law makes this a little bit different. Some of the cases might suggest that it does.
I'm grateful for that indication, my lady. So, as I've indicated, my sort of scheme is to set out the positive grounds of appeal, as it were. It is my submission that if one looks at Test A, we'll look at it in due course, but paragraph 13, it summarises the basis on which the court would intervene in a cost decision. And that's an error of principle or approach. I say there's both. You leave it out of account something important and relevant. I say that's also true. The decision is wholly wrong, and I say, well, in this case, it's a binary situation, so either making a penalising award against the Secretary of State or not, so I would say it's wholly wrong in that sense. And the decision does fail to balance the matters correctly and fairly. So the background, I hope the court's aware of it. Obviously, it's a third country transfer back to Finland, because prima facie Finland would be the member state in this context that would be responsible for considering an asylum claim. I've already touched on the fact that the certification, in this case of a human rights claim, is mandatory under the parliamentary regime, unless there's you know, a sort of proper basis in law not to do it, as it were, or fact. That the, just to clear the decks a bit, the unlawful detention challenge, which was part of this, the Upper Tribunal judge found that was irrelevant to the cost of this part of the claim. Of course, the cost of the unlawful detention claim has been dealt with elsewhere.
And your client's been ordered to pay them?
Yes, my lady.
Yes.
But, my lady, it's partly, just to touch on this, this was a Hamati situation, which actually was the cases. So every single detainee is covered by that.
Yes.
in unlawful detention claims, essentially if you're paying damages, you pay the cost.
Yeah.
There are very few situations where it would really worthwhile to argue about the cost of a claim. If you recover anything under a non-lawful detention claim, then normally it's a bit different if you spend hundreds of thousands on a point of principle that then is rejected. There's a very clear demarcation. But normally the cost would follow the event of paying damages. So there's nothing to be read into it for these proceedings anyway, and my submission is that's the finding of the judge. It was put to him and he said, no, these are relevant matters. And so we are only concerned with these proceedings, which is the point of interpretation of EU law and the age assessment point. The court already has these points, so I won't spend a long time on the background. I think my learned friend might take you through some of the background. In terms of legal framework, again, I hope we can take that quite quickly. As my lady indicated, it's accepted on all sides that the Part 44 guidance is broadly apt. Of course, the tribunal doesn't have to follow it, but the tribunal will follow it where it's appropriate. It should be borne in mind that tribunal proceedings are often a bit different, but this is judicial review, so I would accept that in judicial review it's much more like sort of normal high court proceedings. So that's a sort of basis for applying Part 44. Perhaps more closely than tribunal might in other circumstances. The grounds of appeal, as I've indicated, are linked. In my submission, the only other point I would make that's relevant, I would say, on the basis of the sort of general legal framework is an obvious point, but really has to be borne in mind quite firmly, and that's that these are case management decisions, of course, but they're dictated by the overriding objective, which in the tribunal is that matters must be decided justly and fairly. And in Part 44, it's made very, very clear that the court may not make any order for costs at all. There's no obligation to award costs against any party. And so there is really two decisions to be made always. Should costs be awarded? So is there a sound basis to award costs? And if so, what's the principal basis for doing that? It really can't be an expression of disfavour of one party or the other, or some other sort of looser sort of. That could happen if there's a sound basis in outcome, and or there's a particular piece of conduct or something which is a principal basis for doing it. But as I say, it can't be sort of one of these one-line decisions, you know, that really doesn't explain why the penalisation has taken place. So moving on to the particular jurisprudence on the Dublin regulation situation, we do have some case law bang on point, I say, which is a very useful way of unravelling the principles. So can I ask you, I'm picking up my skeleton at paragraph 4.2, and I would ask you to turn to or open up the authorities bundle at tab 15, which is PH error clear. And if we look at tab 15, this is a useful case because it draws together principles that already existed and refers back to case law that was before the tribunal and gives an interpretation of that case law. So in my submission, this very clearly shows where the error of law is and the error of approach too. For both ground 1, which is error of law, and ground 2 is failing to sort of have a correct approach and leaving something out of account that's legally relevant and very important to the outcome. So picking it up, 232, page 232, is the beginning of the case, and that has the head note in it. You can see what's been picked out in the head note is actually really relevant to the reply, in a sense, which is, if one looks at D, you can see that the on appeal will rarely be appropriate for the Court of Appeal, having first decided that the appeal is academic, in this case it would be the claim, to go on to decide whether or not it's tolerably clear that the appellant would have won the appeal for the purpose of determining issues of cost, the appropriate course in most, if not all cases, will be for the parties to agree that it's academic. And so although that's dealing with the costs in the Court of Appeal, an appeal becoming academic, you can see it's exactly the same situation. The reasons for it becoming academic as the situation below here.
I mean, here it was agreed, isn't it? Everybody agrees the claim had become academic. I think in MH there was an issue about whether it was academic or not, so we spent quite a bit of time looking at that and concluded that it was academic in the end. But we can short-circuit that part of the process, can't we?
Well, my learned friends would, I'll leave them to take you there, but they would say that no, you do need to look at how it would have been decided below in terms of...
I think that, well, I had understood that to be on the tolerably clear thing, that you need to, and perhaps then importing a separate element to deal with their delay point, so they knit that in at that point. But I'm sorry, I was just making a smaller point, which is the academicness.
I'll allow them to develop it, and then
Sure.
I'll see how it comes out and respond appropriately. So, although the head note picks out that point, I think that's partly because the rest of it is established case law, as it were, that's been established, and those are the points that I want to take for my positive appeal ground. So we can just pick up paragraph 34, simply because it makes the point about Hamati, that actually the court in that case raised Hamati.
34 is what page, please?
Sorry, my lord, it's on
239.
page 239,
Thank you.
and it's about F. And all that just makes the point I've already made, my lord and my ladies, that everybody in Hamati is entitled to damages. It has no relationship to the sort of facts of the case at all, and indeed the court rejected the idea that sort of reasons for unlawfulness, if you could find some other reasons, were relevant to the damages stated, etc. So, as I say, we don't need to dwell on that, but I'm just picking up that situation that's similar to this one. And then we can go forward to paragraph 42, which is page 240. Starts right at the bottom of the page there. And then the paragraph 41 actually has the bit in the head note that we saw normally when the parties agree that the case is academic. The court then looks at what's the approach concerning the underlying merits of the claim in an academic case, or in a case that ceased to continue. I think that would be the broader way of putting it. And the court looks at RRM, and the point I'd like to pick out is that looking at M, under A on the next page, in paragraph 42, you can see that the court, even on private law principles, the claimant has been partly successful. It's usually appropriate to make no order for costs, unless it's tolerably clear who would have won. So even when you have a degree of success, no order for costs is the normal order.
Now that struck me as being slightly counterintuitive. Do we have RM in the bundle?
Yes, it is in the bundle. It's at tab 9.
There's
But
paragraphs.
I'm not, and we can take time on it, my lady. I'm not.
No, well, I don't want to hold you up. I've got it there, so I can look at it. But
Yeah.
yeah, all right.
So, my lady, it might be because positively awarding costs against someone, my submission needs a positive basis. So.
No, but I mean these days, RM was a 2012 case, but these days, for example, percentage awards of costs are much more common. There's a much more creative, flexible, open-minded approach to. So I think the suggestion, speaking for myself, that if you're partly successful, the usual order is no order for costs, maybe a little bit, going a bit too far.
Might be a more sophisticated, nuanced
Correct.
approach because
Correct.
the court has more tools.
Correct.
I think, though, always, my lady, is that balance, though, between spending a lot of time on costs and energy on costs, arguing about costs, including public funding, arguing about costs, and the court just saying, well, we haven't decided the issue, we can't say there's a winner and a loser, so we can't award costs.
No, but if you have one outright on part of your claim, then instinctively you should get some of your costs.
Perhaps it's too generalised.
I agree. But now we're on that, and then I'll be quiet. But also, in terms of being careful about taking these statements. Of course, my lady was in this case, so she knows it extremely well. But we take paragraph 41, where there's an important caveat about the correct approach, where an appeal becomes academic. It's if you can't agree about the costs, you must go to court. And that's picked up in 46, which needs to be read in the context of 41, where at the end of 46, the court says the appropriate course will be to agree a consent order disposing of the case subject to costs and to ask this court to make a decision. That is on the basis the parties can't agree, because of course the starting point must always be the parties should, if at all possible, agree costs when something becomes academic.
Yes, well, lady, I mean, as I say, I would be very much in favour of that, but I do understand that there are pressures on
I understand, I'm not saying,
funding,
but in terms of broad principle statements.
Damages of the individual, if the costs are not recovered, then there's a clawback, etc., etc.
Yep.
So there may be forces at work that mean that parties that normally would take a percentage view or something of that nature, because of the way the funding system operates, might not be.
Understood. Anyway, this is just a point of general principle and practice, that you accept that there's a caveat in that last sentence of 46, which is if they can't agree, they must come to the court, but they shouldn't, without more, just come to the court.
Yeah, we should all try to agree,
Yeah.
and as I say, one would.
And the other side, Ali, your main point is the 42, 43 paragraphs.
Yes, I'm literally just picking up the review of RM to put it in the context the court put it in, to follow the court's consideration of the jurisprudence through. I'm not particularly relying on RM in any individual sense, because that wasn't a Dublin case anyway, as it were, and we have Dublin cases that are directly on point. So 43 is where it starts to get into the particular Dublin jurisprudence, and you can see at 43b the leading case is referred to as Test Bay, and that was a decision fairly early on. The court may recall there's an awful lot of third country litigation at that time, whereas every destination transfer back country was being challenged on the basis that it wasn't a safe return country. I think Test Bay concerned both returns to Malta and returns to Italy. And so the court was looking there at what happens and came to two different conclusions in those different contexts, reflecting that it does matter what your legal claim is and the degree to which your legal claim has legal challenge to the certificates has been, as the court puts it, vindicated. So the court helpfully summarises Test Bay there, and you can see that this court refused to award costs to claimants, I'm reading from C, who were resisting their return to Malta as they had not been able to show that their certificates had been considered to be made on a flawed legal basis. As I've indicated, certification is mandatory unless there's a basis in law and fact not to certify. And in those situations, in the case of the Maltese, or those who were seeking to resist transfer back to Malta, they hadn't been able to show that. And so the court said, no, you're not having an award of costs against the Secretary of State in favour of those claimants. And then the court looks at ZN Afghanistan, which was in front of the tribunal, and I'll come back to that. And then ARISO, we haven't got it in the manual, we don't need to go there, but it's in accordance with the general principles, as the court says. They illustrate a similar principle, and this is key, which is if the claimant gets the relief, so I mean the legal relief he sought, for a reason which is unrelated to the claim, and you can see here the bracketed example is something where it's the Secretary of State's responsibility, as it were. For example, a certificate is withdrawn for reasons which have nothing to do with the underlying merits of the claim, but because the Secretary of State has allowed the relevant time limit to expire. The claimant is not, for that reason, entitled to his costs when the claim settles. And so that's in a settlement situation, which, in my submission, hasn't happened here, because what's happened here is the claim has become academic, and then there's a consent order, as it were. It's not the situation my Lord envisaged, where sort of beforehand, anticipating the event, there's some sort of settlement in terms of a settlement are agreed.
But those wordings are exactly what you rely upon in ground one.
Yes.
That is your ground one.
This is my ground one.
And you say that in this situation, the reasons it's been withdrawn have nothing to do with the underlying merits.
Yes. And I would in respect of reply, I don't want to anticipate it too much, but you can see the extra layer there, that even if it's the Secretary of State's fault it's become academic, in a Dublin context, by allowing a fraction of time or not doing something which should stop the clock, then even in that circumstance, the court is very clear, and it's because it's not the legal merits of the claim. It's not, this certificate is unlawful because of this, this and this. And that is the basis on which you succeed in your claim in a manner that's relevant to costs. And one has to cling on to that, because otherwise it becomes really difficult. If it's nothing to do with the legal merits, it's very hard then to delimit a proper principled basis to say that the Secretary of State should be penalised by an award of costs against them. And as I say, a claimant who may have brought a completely unmeritorious claim ought to be rewarded in costs, because that has implications in this particular context. Which
Let's be careful about though, taking this out of context. Isn't this considering the question of whether or not the applicant is to be treated as successful for the purposes of Lord Newberger's analysis in R.M. Croydon? And what this is saying is, if the certificate is to be withdrawn because it was legally flawed, then they have been successful. If it's withdrawn for some ulterior reason, then they won't be regarded as having been successful. It doesn't answer the. It doesn't purport to address the broader question of discretion in relation to costs, does it? It's not saying it's not saying in no circumstances in a Dublin case is the conduct of the Secretary of State irrelevant to consideration of costs.
My Lord, I can't set it up as a complete bar on making an order for costs, because I think that there's a two sort of stage process in a sense. Are you awarding costs on the merits, on the basis of who would have won, who wouldn't have won? If not, and that's what this says, no, you can't do that. Are you then awarding costs because someone's behaved badly in the litigation, or for some other reason that the court might award costs? Maybe in some situations, I've heard that the court has awarded costs actually against a government body for not trying to settle something. It's more difficult in public law, because in public law there are principles and they ought to be decided. But say in I don't know, just a sort of negligence claim or something like that, which normally wouldn't trouble the court with, you ought to try to settle. And the public body had just sort of set its face against it, even though in fact the public body succeeded. The court did consider that type of behaviour was relevant to costs. And I'm not trying to shut out some positive either misuse of the court or something that's positively wrong that is a basis for penalising in costs. What I'm trying to demarcate between is a merits-based you would have succeeded in your legal claim, and then other reasons, but the other reasons must be proper principled reasons to do with those proceedings, because you will see that when you look at the case law, actually the court rejects the notion that sort of wider bad behaviour or not good behaviour in immigration matters is relevant to costs. The court very clearly says, no, it's only in the proceedings, but if in the proceedings there is something that's genuinely not as far as wasted costs order, but perhaps something which means that penalisation is appropriate, but my Lord, I would say one can't penalise a party for continuing to defend its position if it's considered genuinely to be a lawful decision. That would be wrong. And I understand the wider context, but as I say, the wider context has to have its place, and that in costs it's not actually that much of a place, and the courts have indicated that it's really the legal proceedings themselves. You have to be able to positively say this has been done, an abuse of the procedure or something.
Or pre-action conduct, failure to comply with the pre-action protocol. So it's not just once the proceedings are up and running, but it's still to do with the proceedings.
Yes.
The conduct of the litigation in a broad sense.
Yes. But I would just add that it's not a means of sort of fining, as it were. You can't sort of fine someone for administrative incompetence or something of that nature. That isn't the use of the costs process. You know, the cost process is there really to sort of, as I say, be justly and fairly applied according to not general distribution of the Secretary of State, but actually something really tangible. Because the problem is otherwise you develop this culture of you always get your costs, so don't worry about it. You know, and that has problems for the court as well as for the Secretary of State. So moving.
So can I just crystallise that proposition, which is that you would say that the first question is whether the case whether the claimant has proved their case is meritorious on the law, and if they have, then cost would follow the.
And would have been decided in their favour, sort of, but for stopping short.
But there is room to think about conduct of the parties, just as CPR Part 44 says, even in public law cases. But you would say that it needs to go beyond some sort of generalised sense of delay. You would need to identify specifically what it was in the context of the particular case that amounted to culpable or egregious conduct.
Yeah, as I say, there is case law that very clearly says, you know, don't come complaining about every sort of feature of this case along the line, you know, delays here, delays there. It's got to be in the proceedings.
And what's that? You say, what is that? Have we got that case law?
Yes, my lady, it's can I come to it?
I just wanted to, if you know what the case is called.
I think it's in ZN itself, actually. But,
it's in ZN, is it?
I think it might be ZN citing another case. That's why I've got.
Fine, let's get there in due course.
I will pick that up as I go through to give you the citation. I think, as I say, ZN is citing back an earlier decision. So, picking this one up, what we get from my lord has indicated that it is very much my first ground of appeal that's there in paragraph 43 at the end there, and you can see it's with reference to ZN, and that's why I then come on to it being in misdirection. The tribunal directs itself to test bay in the ZN, and in my submission gets the wrong end of the stick, and doesn't apply in accordance either with what's said, principles that are extracted, and also the outcomes there. So it wasn't just the court explaining itself, but also actually looking at what happened there. So then paragraph 44 just picks up this point. I don't know how much it matters, but the court does recognise that where a case becomes academic, it's not the same as a settlement. So it's not like the situation where you have a sort of settlement agreement and you can look at that to say, you know, who's conceded what, you know, and use that instead of a judgment almost as the basis for saying who the winner and who the loser is. Because there may be cases where the settlement really indicates that the decision maker accepts they made the wrong decision. You know, there's some flaw in the original decision. So the fact you've got it in the settlement and not in the judgment, because it anticipates the judgment, is a proper basis for award costs against the decision maker. But you can see the court says it doesn't. You can still go on to look at who's successful and who isn't in certain circumstances. And 45 really is just looking at that particular case and drawing the distinction that's clearly there in Test Bay between those returnees to Italy and the treatment of those, and those returnees to Malta and the treatment of those, because we saw two different outcomes in Test Bay, according to whether or not essentially you'd established a legal flaw or an unlawfulness in the decision under challenge. And then in 46, you can see in that particular case, the court goes on then, because it's heard argument, because in that instance it was the appeal court itself that was being asked to sort of decide the position, the underlying points, and so the court then said, you know, unusually, we're going to go on to consider the particular merits in that case, but couldn't have tried harder, I think, to say this isn't the usual course. So it's not a sort of green light for coming to this court and saying, can you sort of unravel all this for us now? So in my submission, it's important with those principles in mind to look at the consent order. This is actually in the supplementary bundle at page 43 and 44. It doesn't say anything other than what we've already recited in the skeleton argument. It might be worth just looking at it. because this must be the keystone of the tribunal's positive decision to award costs against the Secretary of State on the reasoning that's been given by the tribunal on the basis of the order. So you can see that the form of consent, there's no sense of settlement here. It's a series of events and consequences. So upon the revocation of the particular regulation, that's actually right. It's actually the regulation carried on. It would be the underlying domestic legislation. And upon the respondent having consequently withdrawn the third country certificate decision and having confirmed that the applicant's assignment of the claim will be considered in the UK, and you can see there's a bit of a doubt there because there may have been follow-up procedures, arrangements if they could have been agreed either individually with the particular EU states or globally. And upon the parties agreeing that the judicial review claim has become academic, so there's an agreement here only as to it becoming academic. By consent, it's ordered that there's leave to withdraw the judicial review and that costs will be determined on the basis of cost submission. And in my submission, that's important. The basis on which these costs could be determined here is on the cost submission. And that's what the tribunal did. So when we look at the tribunal, that in my submission it failed to understand the case law that was applicable, and it overlooked matters. But it did purport to decide it on those submissions. The Upper Tribunal decision is in the core bundle at page 60.
And if Mr. Oppleton approved it, this consent order, you can see his signature at the top.
Yes. So pulling up the decision that's under appeal, I think I keep referring to it as an order, but I think typically the tribunal doesn't make orders next determination. Page 60. So it recites the context, that the reasons given, you can see, by order agreed between the parties and approved by the Upper Tribunal, by Mr. Oppleton, the Vice President, leave to withdraw judicial review and liability for costs to be determined by the tribunal. The recitation that it was the better recitation actually, that the regulation no longer applies in the UK from 11 p.m. on the 31st of December. Consequently, the respondent withdrew the relevant third country decision in this matter and confirmed that the claim would be decided in this country. Then the procedural history, there's nothing really to pick out of that. It's a recitation of what went on. In my submission, all that goes before isn't actually relevant to costs, and that's really what the tribunal decided. Perhaps picking up, without anticipating too much, paragraph 13, and you can see the matter came before Upper Tribunal Judge Whipple, who declined to conduct a fact-finding hearing. So no acceptance of this being attributed somehow to the Secretary of State in that paragraph. Then there's the appeal. And then amended grounds of claim. This is paragraph 16, dated 30th of April 2020. And then there are two grounds of challenge. And then there are directions, and there's a direction to determine ground 1 as a preliminary issue. 19 just records that the unlawful detention claim and the costs have been decided by another order. And then
So did the, I was going to ask about the amendment, before the 30th of April 2020, what were the grounds of challenge?
I think it was crystallised by the amended grounds.
Right, so there's no change of, there's reference in this judgment somewhere to the fact that the ground was always advanced, but the way it was advanced was not consistent.
Yes, I think it's fair to say things have evolved.
Right.
So the particular point that was being argued on the basis of the Dublin regulation hadn't really sort of, in a sense, they're all grounds of challenge on the basis of the terms of the regulation, but the particular point hadn't really been crystallised. But I take no point on that in the sense that I think these things do often evolve.
Do we have the directions of the 29th of July 2020?
I think they should be in the supplementary bundle, maybe. Can I come back to that?
Yes, of course.
So just going through the parties to submissions, you've actually got those submissions in the bundle, the cost submissions that are there. They're summarised by the judge. The respondents haven't taken any issue with the judge's decision at all. There's no cross appeal or any attempt to say the judge was wrong in his decision or finding. The decision starts at paragraph 22. The judge refers to, in the second sentence of paragraph 22, ground 2 of the amended grounds of claim raised a complex issue of law. So it's not ostensibly straightforward. And this is a tribunal who presumably wrestled with it after having had a hearing on it. The latter was addressed before the tribunal at the hearing on the 5th of October, but no judgment was handed down when the matter being settled by agreement of the parties save as the issue of costs. But what's the settlement there is, as you've seen, just that it's academic. Ultimately, the applicant sought to prevent his transfer to Finland, so this is the reasoning of the decision under the mechanism in Dublin 3 regulation for his application for international protection to be substantively considered in the UK. Ground 1 is the age point. Ground 2 arose, it was said, by application of the mechanics of Dublin 3 regulation. Ultimately, the consideration of the amended grounds became academic upon the UK's withdrawal from the EU respondent's decision. So there's a very clear acceptance there that this is the basis for the judgment that then follows on costs. The applicant conducted his claim reasonably and obtained a material part of relief sought or a substantially similar relief, namely that he was not transferred to Finland, and his application for international protection was considered by the respondent. And you can see the judge is citing to himself in paragraph 24 there, ZN. But in my submission, the judge isn't applying ZN correctly, and isn't applying at all the principle in ZN, which I will come on to show you. 25, this is where the misunderstanding comes in. Success in public law proceedings may be considered by reference to what was achievable. But what was achievable here was the quashing of the certificate for being unlawful. That's what the issue was. And that's sort of unlawful from its outset. And that can have, obviously, Hamati intervened here. But if the certificate was unlawful, then detention was probably going to be unlawful on the basis of the certificate, etc., etc. There were real implications of an unlawful certificate, and that's why the matters were being pursued. To have a prospective no power to make a certificate after withdrawal from the EU is a very different situation.
You say something, don't you, that after paragraph 45 of MH Eritrea, that this point has been determined by the Court of Appeal.
Yes.
So that's the end of, you say, of any argument about whether this is correct. It is plainly not correct, because the Court of Appeal has said in exactly the situation it's not success.
Yes, and the Court of Appeal has interpreted Tesfaye and interpreted ZN Afghanistan within MH Eritrea to show what the principles are. So you can show the identifiable error of law by reference to MH, not just its sort of statement, but also that this is why the judge has got it wrong, because, like others, he's misunderstood the circumstances in which you can say success in public law proceedings.
Yes.
And that's wherein lies the real need for care and the need for being very precise.
And if MH Eritrea is binding, then there's not success, and he doesn't go on, as your ground 2, to consider tolerably clear question. So you say that there were those two, that combining those two errors, he couldn't come to this conclusion.
Yes.
Then that means that the question is then at large as to what the right decision.
Well, I say no, because firstly, just on the point my Lord has just made, I would just say there's no suggestion this decision is per incuriam, or there's very limited circumstances in which the Court of Appeal, and usually the Court of Appeal really can't go against its own decisions compared to the Supreme Court or the High Court.
Who's saying which decision? MH Eritrea.
Yeah, all I'm saying is, just to support what my Lord says, there are actually very limited circumstances in which the Court of Appeal can sort of differ from its own.
But it's not been suggested that we should.
It's not been suggested here. That's just the point I'm making, that it's not often. I have many cases where there's a sort of idea the court can have another look at it and can just sort of say,
But it's a decision on exactly this situation.
And that's what I'm saying. And therefore you'd have to say it's per incuriam, which is those very limited circumstances, the Bristol aeroplane situation.
Yes.
And no one's suggesting that's these circumstances.
That seems on the face of it. Your argument is very simple.
Yes.
You say that, and perhaps one can say that Upper Tribunal Judge O'Callaghan, of course, was making this decision without the benefit of MH Eritrea.
Yes, but actually, that's why I go on to say that without drinking down at all, it was already there in Test Bay and in ZN.
But it doesn't matter. It doesn't matter, does it?
My Lord. But
it's
I
now
would say
clear.
It is a proper material area of law by misdirection.
So the real issue, you would say then, is that we have to exercise the discretion afresh, don't we?
No, my submission is that I'm entitled to have the decision below set aside.
Yes.
So the question for the court would be, what happens next? Should it be remitted so the tribunal below can decide it? Are there very limited circumstances in which this court should sort of embark on making the decision sort of for itself? Is that necessary? And in my submission, in a sense the court can do it because the court can say, applying the case law, it's very clear that this is the outcome on the case law, as it were, without having to get into rehearing the sort of costs of. So this might be one of those circumstances, but in a sense, because the ultimate situation should be no order as to costs, it is slightly different to where the situation it needs to be remitted in order to reconsider as it. My concern, perhaps putting my cards on the table, is that there are very limited circumstances in which this court should act as a first instance tribunal. And that's really what my learned friends are asking you to do, to sort of go back to the beginning and look at all the proceedings and look at who did what when and say, Part 44 penalised because of conduct of litigation. And that's what I'm concerned about.
So just to answer my Lord's question, what is your primary case on relief?
My primary case of relief is that I'm entitled to have the order below set aside. There's a clear material error of law.
And then what?
That in my submission, there's no utility in remitting this back to the tribunal, which is what would normally happen, because there really is room. It's a binary situation. There really isn't any room for one answer here on the law, because this is a situation where.
Right, so don't remit, just make a no order as to costs.
You don't, just leave it as it is.
And you say in the absence of an order, that is the order.
That is the order, so it is slightly unusual from that point of view.
So silent.
And I would also bear in mind proportionality and the overriding objective here, that there is a limited amount of resources that ought to proportionately be spent on arguing about costs. So even if there was a theoretical other basis for awarding costs of this court.
Forgive me, that I don't think one can just say we don't do anything and then there's no order. I don't see how you can do that, because there has been directions for the issue to be determined. The issue has to be determined. We can't just simply say we're just going to leave that with no order.
Well,
made, because that would then there would be an extant application or hearing on which hasn't been determined. I just don't think we can.
My Lord, I'd obviously be content with this court saying there be no order as to costs in the order. What I am concerned about is having at this level a sort of first instance argument about exercising any discretion according to the conduct of litigation, or even the outcome below, because in my submission that's not an appropriate use of this court's time. And if that is what the court is minded to do, it would be better to remit it, however regrettable, because that is a first instance type of situation.
Is there a point of principle here or just practice? I mean, I have to say, in other parts of work that I do here, tax typically, I spend quite a lot of my time remaking decisions in this court that have, for one reason or another, fallen apart or been wrongly taken below. Why aren't we in as good a position as an upper tribunal would be, just to have a look at the paperwork and see where we think the costs land? If we're with you that there's been an error of law at this stage.
Because in terms of the proceedings themselves, the tribunal is the appropriate. The tribunal had carriage of these proceedings. One takes an example of one of the underpinning of my learned friend's arguments is that the Secretary of State is somehow responsible and should be penalised in costs for the decision of Upper Tribunal Judge Coker not to hear a case. That's one of the mainstays. Now, the tribunal has ruled on that, and I say that ruling can't be interfered with, but my learned friend says it can. If you are persuaded by that, and this court wishes to look at the reasons for all the effluxion of time, put it neutrally, in this case and the way the proceedings are, my submission that you have to look at them all. You can't sort of say, well, we didn't like that bit, or we didn't, because it may be the other party.
But surely, as Ms. Broadfoot does, she's entitled to raise a respondent's notice challenging paragraph 26 of the judgment, saying uphold the decision for different reasons. The judge was wrong to say delay was not a factor to be taken into account. There was here culpable delay on the part of the Secretary of State, which militates in favour of the order that was made. Why can't she properly raise that on this appeal?
Well, my understanding, I don't want to take a technical procedural point, but I thought that would actually be better to take by way of cross appeal.
Understood, but we're talking about as a matter of principle,
yes,
where we go on
it's
relief.
the argument, not the...
Why is it not possible for that point to be raised by a respondent's notice as it is?
Well, it can be raised, my lady, but I would urge the court to decline to decide it.
I see.
You can see that it's not really... if anyone should decide what the motivation for an upper tribunal judge was in that particular context, rather than blame the Secretary of State for somehow... this was the point of the judge's own motion that was raised at the proceedings that they were anticipated. You can see it's a difficult...
What was?
The Coker
The
point.
upper tribunal judge Coker's
The Coker point.
to decide the case that had been put before.
Upper Tribunal Judge Coker raised it of her own accord.
So, in my submission, if the court is persuaded that those are matters that ought to be considered relevant to costs in this particular context, where, in my submission, it's very, very tenuous, because you've got my submission to principle. It's either to do with the merits, that's one side. We're now in the territory of, is there another reason to penalise the party and costs? You've got my submission, there has to be a very positive reason for doing that. Can't be a mere reflection of time. We've already seen that reflection of time under the Dublin regulation, for whatever reason, isn't a basis to do it. It's got to be conduct for litigation. And in my submission, you can see it's a very nuanced and difficult submission for my learned friend to make out in front of a tribunal that's not been engaged in the proceedings, to say that these particular steps are somehow so much the Secretary of State's fault that the Secretary of State should be penalised. These things happen, and the appropriate order in my submission is no order to cost, less as a positive basis.
So are those your submissions in answer to the respondent's notice? Because it is before us. And
It is, but my lord, I did want to see how they were developed and come back to you, and I think that would be a better, more informed way of dealing with it.
I see. Yes.
But of course I'll answer your questions. So I think we're getting through quite quickly actually, so I shouldn't be long on my feet now. So we can see that the tribunal, although it accepts all those points that one would think on NH Eritrea would mean the conclusion follows, it reaches the opposite conclusion, and that's because it's understood SFA and ZN Afghanistan. I did just want to pick up, actually, the tribunal cites ZN Afghanistan at paragraph 24 of that judgment. It's tab 11, is just worth pulling that up. This is in the cost report. It's page 157 at tab 11 is the beginning of the authorities.
Ms. Anderson, I'm sorry to interrupt. I just need to ask my lord for some technical help. Where's my index gone? Don't worry.
I think you just have to. I know you're not on
don't worry, don't worry.
Bookmarks.
They've got bookmarks on the left.
Thank you. Thank you. Carry on. Thank you very much. Apologies
Sure,
for interrupting.
So if we pick it up, page 169, can I just ask you, I know it's quite a chunk, but it will deal with sort of some of the other points as well. Could you read through from paragraph 66 to 70? I only ask you so we don't have to come back to it. Can you see the latter paragraphs are more relevant to
66 to 70.
66 to 70.
Of ZN.
Of ZN.
Thank you.
Starts at page 169. Actually, sorry, it's 170 to 66. And as these things happen, for some reason the sidelining on paragraph 68, which is the key paragraph, has dropped off. So can we have some, I'm afraid, some virtual sidelining put into paragraph 68?
Just remind me, whose judgment am I reading from here?
My name is
Is it the bit of thing? Thing.
This is the answer to your question.
Yes.
What is the paragraph?
So, my lady, actually, was an answer to your question. It wasn't actually referring back in ZN to another case. It was to one of the questions from the judge of the panel in ZN itself, a question from Lord Justice Leggett. So you can see that it's paragraph 70, that it must be something to do with the proceedings themselves. It can't just be sort of general criticisms, the litany of criticisms of the Secretary of State, which sort of means you get fined and costs. Sometimes really on a very difficult to understand basis.
Well, I'm not sure that's what it says. The issue was raised by Lord Justice Leggett, and then there is a for example. It's the concept of the party in the context of litigation itself, and then certain formalities. So what you're saying is it has to be to do with not complying with formalities.
Well, what I'm picking up, my lord, is in the middle of that paragraph. In my view, you can see the court comes back to the underlying reason and sets it out clearly there. The reason for that is still to do with the conduct of the other party in the context of litigation itself.
Yeah.
So it's conduct in the context of litigation, which is the sort of dividing line. And so you have to put these dividing lines if you're awarding costs in some orderly context. Otherwise, you do get misunderstandings, and that's what this guiding principle is here. Conduct of litigation, behaviour. That's why the costs. That's why it's the legal costs of those proceedings.
It's interesting, though, isn't it? If you think about a fraud case, where the fraud is the essence of the action, so it's outside the conduct of the litigation, that can be used as the basis for an award of indemnity costs, can't it?
Yes, but you can see that's a really specific. It's a sort of bad faith, or it's a very.
But it breaches the principle.
exceptional-
It breaches this principle if you take it too far.
Yes, although in my submission, the power to award costs has to be exercised judicially, and it's the power towards cost of those proceedings. And if you do step too far in awarding costs as a fining system for bad behaviour, assuming generally, you can see that that is starting to go outside of really what the remit of the discretion is. Because it may be, and it's dangerous, because it may be some judges would approve of some things and disapprove of other things, etc., etc. There needs needs to be some clear guiding principles in order to have the sort of stability and coherence that's necessary for fairness.
I'm all in favour of clarity, but the more I read these cases, and going back to where I expressed my reservations about Lord Newburger's judgment in, what was it, MN, if you actually read the paragraphs, they are so heavily caveated that it may be that what Lady Justice Lane said in the paragraphs that triggered my interest need to be read in full context by reference to those paragraphs, because in fact Lord Newburger is very cautious about laying down general principles. It's the language of often or sometimes, but every paragraph says how fact-sensitive the whole approach has to be. That's not to say there isn't some general guidance in there, but I'm wondering whether there's a tension between one's natural desire to achieve clarity and certainty and making sure that actually it is all ultimately very fact-sensitive. And under the very broad principles in CPR 44, all the circumstances of the case.
My lady, I certainly would accept that. The only thing I would raise, though, is that in a cost situation, you always have that tension between getting the perfect sort of and the resources that are necessary, arguing about costs to achieve that. And so the court has accepted a sort of broader brush approach.
I certainly accept there's a general, very clear statement of principle in the authorities on the causal link point. Yeah. I'm just wondering whether this is, again, it's all a bit more nuanced. The words of usually and often and sometimes and all the rest of it. But I think I understand the sentence you rely on in particular, paragraph 17.
And as I say, in order so the parties sort of know where they stand and don't have to keep coming to litigate, clarity has that extra dimension here, because we're asking people to do it on their own without coming to the court. So I think that's why the court has been quite astute to try to highlight these principles.
And just to interrupt, finally, because I don't want to mislead anybody, thinking through the fraud example, the imposition of a different basis of assessment could be said to be different to the order to be made in principle.
Yes.
If you see what I mean.
Yes, the case
that the moral turpitude factor comes into the basis of assessment rather than the order in principle.
Yeah.
So it may not be that helpful. Yeah.
Just thinking about a parallel private law situation. Let's say that a landowner commences proceedings against somebody for an injunction, let's say for trespass or for nuisance or for some other wrong against them as the owner of the land. And the matter proceeds, perhaps there are interlocutory applications, interlocutory injunction. It ends up at a trial. And there's a lengthy trial, lots of evidence caused, and the judge reserves judgment. After that, the landowner comes along and says, I've sold the land. I no longer want or need the injunction. The claim is academic. There is then no need to determine the legal merits, and perhaps the court won't. The claim is settled on the basis that the claim is withdrawn or is settled on the basis of no order or whatever, and the court is then asked to decide the costs. I think in that situation, if the claimant said, well, actually, there's no determination of the legal merits of the claim, and my decision to the sale of the land was a subsequent event which isn't related to the merits of the claim, I think the court would have very little sympathy with that. I think the court would say, if you knew or had in mind that you might sell the land and this would become academic, then really you've wasted all the time and all these costs because you knew that this was you must have known at some point this was academic, or you've made it academic. I'm not sure the court wouldn't say in that situation you should pay the cost.
Well, my lord, I certainly see the point. What I would say is this really is very, very different from that. Not only because we've got case law bang on point, but also because in that instance it really is the landowner who sort of has control over the very specific thing and is saying, because in fact in land law sometimes emotions run so high that people actually continue even if there's really no rationality.
We'll leave that
to
aside.
it, etc.
Leave that aside.
It's the action of the landlord, isn't it, in selling the property that renders it academic. And in circumstances where they're bringing the action, and then they just say, "Oh, I don't need this anymore." What's happened?
Well, let's say he knew. Let's say he knew at the time of the trial. Maybe both parties knew that the property was up for sale.
Yes. Well, then perhaps that's something that the because it's the landlord in that situation is bringing the action, and then he just says, "Oh, I don't need it anymore." So in a sense, he's instigated, and he would actually normally, because he would then withdraw his claim, and actually under the CPR, normally when you discontinue, you actually bear the cost. You have to actually under the CPR ask the court to make a different order. So the CPR already covers that discontinuance, because he would be discontinuing the action.
Well, let's say the parties agree that it's academic, and they agree that there will be no substantive order, but they leave it to the court to decide costs.
Well,
we can make the situation parallel, can't we?
I don't think so, my lord, because as I say, in that situation, what you put to me is the landowner is bringing the claim, the trespass claim, knows all along that might not need it, but for whatever reason, by his own action, then sells the property so doesn't need it anymore, but would then need to discontinue. Otherwise, and if he discontinues, that's the only way of getting out of those proceedings that he's brought. He has to discontinue them, and then automatically under the CPR.
I understand that, and you're saying it's not. If there's a discontinuance, I understand that. I understand that difference, but I asked you to assume that that's not what happens. What happens is the parties agree that there'll be no order.
Well, my lord, then I think I'm afraid it's just the responsibility, I suppose, of the person responding to it. That
So you say it's not a particularly helpful analogy.
I just say that it's interesting to examine the principles, but I think it's so it's distinct from what's happening here to the extent that it perhaps shouldn't trouble the court too much. I can see what my lord is grasping at, because the Secretary of State is seen as being in control of all these matters. What I would actually say is, of course, the withdrawal was a referendum and was a sort of broader situation. So it's not.
No, the withdrawal wasn't a referendum. There was a referendum.
Yes.
But thereafter.
It was a democratic decision.
Well, I don't think when you look at the politics of it, the fact of the matter is that the government, all we need to say here, knew that on the 31st of December, by virtue of its actions, and of which one doesn't need to look at how it came about. The fact is that there would be a withdrawal on the 31st of December, at which point the Dublin 3 came to an end. And what I can't quite follow at the moment, and this is where we started, is what Secretary of State thought was going to happen as of October. Why was it? What was? How was this going to be dealt with? How these costs? What were they being incurred for on this preliminary issue? Because it was never going to determine the matter, as far as I can see.
It was always argued on the basis this is the point of principle that's worthwhile.
Well, it might have been for you. It might have been for you, but if the government wants to determine that point of principle, when it's never going to be a.
It might have been determinative for the applicant.
Yeah, I was going to say, in all fairness, the government didn't really want it determined, but the government had to decide how to respond to a legal claim that's being raised. If it was conceded, it would concede the point of principle. That's the difficulty.
And it wouldn't have. I mean, you still have the costs issue. I suppose that the logical end point of this argument is possibly, and this is just for the sake of argument, I'm not saying this is what should have happened, but that the government should have said, let's not have the preliminary issue, or we'll just accept now as a pragmatic thing that we're going to quash the certificate now in 2020, and so you might have saved a bit of cost, but you'd still have the argument we're having now, wouldn't you, about what happens to all the costs of the action since 2016.
So prospectively going forward, it's different to accepting it's unlawful going back, and accepting it's unlawful going back could have wider consequences. But also, you would need instructions from those above, that there would be nothing in place. You know, that this is the end. And, you know, as I say, I'm afraid it happened how it happened. It was envisaged that there would be a judgment, and so that would determine the outcome. So it wasn't envisaged.
But it wouldn't determine the outcome.
Well, the outcome of these costs that we're arguing about now, which is the cost of the preliminary issue.
Aren't we arguing about more? It's just the cost of the
Well,
preliminary issue,
it
isn't
is
or
the
the
whole
action?
proceedings,
It's the whole
as
action.
it were. But if it, you know, there would have been a determination of the validity of the certification.
But the preliminary issue costs are presumably the main costs, are they?
Not if the aid assessment had gone ahead. But certainly at the moment, I really can't speak to the division
Yes.
costs in this, and I don't want to hold you
Yes.
up, my lord, because I really am nearly there. I want to overstay my time. So, in my submission, the causal connection point has already been highlighted from the paragraphs I've just directed the court's attention to. There needs to be this causal connection, and that's how one navigates through these difficult questions, is to always have in mind the legal proceedings and what the legal issues are. Because the circumstance for determining who the successful party is, normally it's done by decision. It's not done by decision. The court says exercise caution. You know, it's only really where you can say that the legal claim has succeeded, that there's a causal connection between those arguments. And in my submission, that would mean that the decision was unlawful. And that's not at all what's been decided here. There's no settlement that's the sort of shorthand for the court deciding it. That's really a tacit acceptance and capitulation. And indeed, in fact, if we had settled beforehand, I'm sure the argument would have been that the Secretary of State was effectively accepting that the decision had been unlawful from the outset. So we've got those principles. My Lord already has the point that, you know, the essence of my case is really quite a short point on the first ground. On the second ground, that before making any order toward costs on the basis of success, if a judge is going to go on to do that, if he's not applying the case law, then he needs to actually positively say it's tolerably clear which way the arguments would have been decided.
That's paragraph 46 of MH Eritrea, isn't it?
Yes.
45 is not success, and 46 is you go on. You can. It's not the end of it. You can go on to consider tolerably clear.
You don't have to, but you can.
Yes.
So because.
But you have. But you couldn't say. You couldn't. Your point is you can't do what was done without going on to that stage.
Yes.
And that comes from MH Eritrea.
Yes.
Yes.
And MH Eritrea really reflects the previous case law, as it were. So we can call it a shorthand for what goes before,
Yes.
because it very clearly pins it to the previous case law.
Yes.
So, and very clearly, the judge doesn't do this here, because he doesn't say, you know, I heard the arguments, and for me, although we haven't decided.
We're cutting you short, but it's clear that that wasn't done.
Yes.
And the reason he didn't do it is because he had said that there was success already, so he didn't need to go on his approach. He didn't need to go on to that.
Yes.
But if he's wrong about success, he would have needed to go on.
If that's how he was going to decide it, he
Yes.
didn't have to make an order for costs. He could say, looking at broadly, as judges often do, standing back broadly, I consider no order of costs as the appropriate order here, and no one could have challenged that, because that is what Part 44 says. You know, you make a decision whether to make an order of costs, and then if you're going to, you look at the basis for it, and so on and so forth. And so if he was going to go on and look at other ways of approximating the success or failure or other reasons to do with the conduct of litigation, then he has to take all the relevant circumstances into account. And now ground two is that he didn't, because he didn't take into account that it was not tolerably clear, sorry for the negatives, that this wasn't a case where it was tolerably clear what the outcome of the preliminary issue was, or even...
Well, cutting it to its bare bones, his decision was that the AI acted reasonably and was successful.
Yes. And that he thought that was enough to make an order
Yes.
penalising the Secretary of State. My submission is that that's not enough. So
You've explained that all very clearly. I think
Yes.
we've really got that now.
yes, my lord. I'm not really. I'm just double checking to see if there's anything else that. The only points, and this is perhaps anticipating the respondent's case a little bit, but you can see the judge positively rejects the arguments that were put before him by the respondent in this court, that while the delays all the Secretary of State's responsibility, and that he is successful by reference to the unlawful detention proceedings or looking at things overall. It's very clearly the judge is saying, Tesfaye directs me to say, looking broadly, they're successful, and that's where his error of law comes in. So, if I had to put it on an alternative ground, it is this idea of not taking into account relevant license, and that's two. So, in summary, I say there's a misdirection of law and approach applying to Tesfaye. There's a failure to take account of important matters, and that did lead to the wholly wrong outcome of binary here. And in my submission, the order ought to be set aside. Where there's a material error of law, it's very rare that the court will decline relief, because normally, if there's an error of law in the decision, you're entitled to have it set aside. And I ask for it to be set aside here. We've already canvassed relief, so I won't take up any more time in the court. And as I've indicated, I'll leave matters. So my reply might be slightly longer than the normal, just because there might be more to respond to.
Thank you very much.
These are my submissions.
Thank you. Rolf.
Thank you. I'm going to make my submissions under 4 general headings. The first heading is I'm going to take you through a short amount of the procedural history, because it is actually important to understand what the claim was and what happened at the various stages. The second heading is to take you to the principles that apply in a cost of appeal. I will then deal with whether the Upper Tribunal judge made an error in law, taking the grounds in turn. And then finally, the fourth point, if you're not with me on that, I'll make short submissions as to what you should do and deal with our respondent's notice. Because my submissions require placing the claim in its context, I need to take you to a couple of documents. Could I just start with the actual claim form, which you haven't looked at? That's in the core bundle at page 114. And the page 115 contains section 3, the details of the decision to be judicially reviewed. Section 3. And there are 4 details, decisions given. The decision of the defendant to assess the claimant as an adult. The decision of the defendant to certify the claimant's asylum claim on safe third country.
Forgive me, I'm really sorry. I've somehow got the wrong. Can you give me the reference again?
Yes, it's page 115 of the core bundle. I hope it doesn't have a different. But the problem is that new material was added to the amended core bundle, so the PDF number is different.
I'm 115 of the core bundle.
Using the numbering on the bottom. Let me see what page it is.
Applicant's cross submission.
It's 15. If you.
It's 155.
Thank you.
155.
It's 155 of the PDF's own pagination.
Yes, I have it now.
And helpfully, the number at the bottom is 115, and that's because skeletons were added in, which basically
It's
shifted
changed.
all the numbers.
So the electronic numbering does to coincide with.
No, it doesn't. So my apologies for that. I should have had both numbers available. So page 115 of the bundle, electronic number 155, section 3, 4 decisions. Decision to assess the claimant as an adult. Decision to certify the claimant's asylum claim on safe third country grounds. Decision to set removal directions to Finland, and the decision to detain the claimant. And the dates of the decision are given underneath, and as you can see, the first 2 were they were in August, September, October, and ongoing. The position of the claimant was set out at paragraph 1.2 of the claim form, which is page 160 electronic numbering, page 120 of the bundle. And the core of the claim is at paragraph 1.3. C claims that the defendant has failed to adopt a lawful procedure which assesses his age and safeguards and promotes his welfare, that he's been unlawfully detained by the defendant, and that the defendant is prohibited from removing him to Finland under Dublin 3 regulation as he is a minor. So that's the core of the claim. The then claim form goes on to explain why those propositions should be made good. And then I just want to ask you to look at paragraph 3.11, which is electronic numbering, page 169, internal bundle numbering 129. And you'll see that what was being asserted was that the bit that follows the citation from RA against Croydon in the Supreme Court. Accordingly, it is for the court to inquire and on the available evidence to make a decision on the balance of probabilities. So that's what they were saying needed to happen in relation to the termination of age, that the Secretary of State had wrongly and unlawfully made decisions based on an age assessment that was itself unlawful. And if that age assessment was itself unlawful, then all of those decisions would also be unlawful. Because the Secretary of State would have to take a new decision whether to certify or whether to detain or whether to remove on a proper basis of age assessment. So that was the core of it back then. And these points were all taken in the pre-action protocol letter, which is not in the bundles, but we've got it with us if the court is interested. And the Secretary of State's response, again, not in the bundles, but again, we've got copies, was we don't agree, we were entitled to take these decisions because the underlying age assessment was lawful. Now, could I please ask then the court to just turn up the chronology attached to our skeleton argument, which is at page A33 of the bundle, but in the electronic bundle,
98.
That sounds right. Working half from paper and half from electronic bundles actually is sometimes a recipe for confusion, for me anyway. Yes, so if there's a chronology, and I'm not going to take you through all of it, but what followed, bearing in mind this is 2016, October, if you turn over the page to page A34, is there are no less than 4 applications, all those applications in 2017. So permission was granted in November 2016, the Secretary of State agreed it was arguable. And then there were no less than 4 applications by the Secretary of State to serve detailed grounds of defence. And then there was, you can see at the top of the next page, there was exchanges about whether the claim should be stayed on the Secretary of State's application pending the Court of Appeal decision in Hamati and others, which of course at that point you can see from the date that's given there that it was some way to being decided, and the decision of the Upper Tribunal, BF Eritrea, unless AI made submissions to the contrary, which they did. And then 31st of August 2017, Mr. Justice Swift refused the Secretary of State's request for a stay, and the Secretary of State was ordered to serve detailed grounds of defence, and parties were required to file agreed directions. Now,
I mean, sorry, going back to the extensions of time between January and April 2017.
yes.
Is there criticism made of the Secretary of State's applications for those extensions? Because if so, we don't know the basis of them, except to say that it looks as if the reason was that further age assessments were being arranged, which was agreed between the parties, would assist both sides in agreeing with their respective positions.
Well, can I hold my pen on the answering that question just for the moment?
All right.
Because once the stay on the back of the Hamati litigation, which was then called something else, was refused, what then happened was the parties went into considerable negotiations, and I would now ask you to go back to the supplementary bundle and look at the consent order dated the 7th of March 2018, which is at page 13 of the supplementary bundle. And the very first recital states, upon the defendant conceding that the decision to treat the claimant as an adult and his subsequent detention as a result was flawed and in breach of her policy. So, at that point, just on this alone, the claimant was vindicated in their claim, because it was their case that the decisions that were challenged were flawed because they were predicated on the Secretary of State's belief that the claimant was an adult, when in fact, as pointed out, that underlying assessment was itself flawed. But, so had the matter gone to court, we would say, at that point, there's no doubt but the court would have quashed all those decisions. The Secretary of State would have to remake them. But of course, having then conceded that the detention was unlawful, the question of IA's age remained relevant. And it remained relevant for two reasons. It was relevant at the time, 2017, 2018, because if AI was a child, then that made a difference to the amount of damages that they might recover in unlawful detention. That was the first reason it was relevant. The second reason it was relevant was because, of course, it would have been open to the Secretary of State to recertify on the basis of a new assessment, provided that the assessment was lawful. So the parties reached an agreement which is recorded in this consent order that the claimant's age is to be judicially determined upon transfer from the admin court to the Upper Tribunal, that's paragraph 1. The Upper Tribunal is to set management case directions and for the matter to be listed for a substantive hearing in the Upper Tribunal to judicially determine the claimant's age on the first available date that suits both parties. So the reason I took you to paragraph 3.11 of the claim form was to show you that what was being asserted was that actually if there's a proper dispute, then the matter it's a question of precedent fact and the matter has to be judicially determined. The mechanics of doing that by way of practice is not for the High Court to have an age assessment determination, although there are some cases that did that in the past, but rather to send it to the Upper Tribunal, which is used to dealing with fact-finding disputes, and for it to be determined there. So in a sense, all of this reflects what was being said at the outset of the claim and what was set out in the pre-action letters. Now,
you may be about to get there, but the costs on this consent order were reserved.
They were reserved.
And that means, can we just go forwards?
Yes.
What happens next? There never was an age assessment determination, so those costs are still at large, are they?
Exactly, but that's why they are still at large. But now, given that where we are, I'm going to submit a bit further down in what I'm going to say, that actually, if one just stops for a moment, there can be no argument at all that we would be entitled to our costs, at least till the consent order in 2018. But obviously the costs were left open because it was agreed that the age of the individual was relevant to the damages, because that was believed to be the law at the time, and secondly, it was relevant as to whether or not a certificate, effectively the Secretary of State would in due course be able to remove the individual to Finland or not.
Well, I can see why it's relevant to those matters. I'm not sure why it's relevant to costs. Why shouldn't you have had your costs at that date?
Well, at this stage,
What are they reserved for?
well, I think I take your point that they're reserved because one is then going to look further at what happens next.
Yes.
Right.
Well,
Normally you reserve on the basis that the court to which the question of costs is reserved will be in a better position to decide costs than the present court. And so what that suggests to me is that it was common ground that the costs so far incurred, where they fell, depended on what the ultimate answer was on age assessment.
I see that point, and of course one is in a different situation when negotiating a consent order at that point in time than where we are further down the line when other things have happened.
Sorry, it seems very clear to me that the costs that were reserved by this order were disposed of in the subsequent order that we see at page 40, which was the post-Upper Tribunal Judge Coker's decision.
Yes, so
So that's where they ended up. And we can see that because we see from the recital, the fact find to determine age. Sorry, it's my fault. It's Master Meach's.
But that's the unlawful detention only.
Well, you say only, but it does encapsulate, or at least refer to, the fact find to determine age. And your submission was that was age remained relevant because it went to quantum.
Yes, now, this is why the procedural history is important, because in November 2019, Hamati came out, and that authority determined that the Secretary of State's policy of detaining was unlawful at large, effectively. Yeah. So it didn't make a difference at that point anymore. So before Hamati came out, that was...
age made no difference either as a matter of principle or quantum?
The age made little difference to the question of quantum of damages.
I see. So pragmatically you take into the question of age an agreement on quantum.
Correct. So, and actually you can see that that's effectively exactly what happens. If you look at the position statement that was filed for the hearing in the Court of Appeal from Upper Tribunal Judge Coker's decision, the position statement is at page 122 of the supplementary bundle. And you'll see that there's a heading on page 123, remittal to the Upper Tribunal. The supplementary bundle, my lady.
So I've got the appellant's position statement. Where do I go next?
So go to the second page of it, so paragraph 4 onwards. So the parties, you can see at paragraph 4, there was a draft consent order, but actually the court, Lord Justice Dingman didn't agree with it, so in fact do that. But in finding the draft order, the parties agreed it was appropriate for this matter to be remitted because the disputed question whether or not the appellant was a child when he entered the United Kingdom remained relevant. First is the question of whether the respondent is required substantively to consider asylum claim. That's the third country point. And secondly, the question of quantum of damages for accepted false imprisonment. If the child were... I can ignore paragraphs 5 and 6. 7. There are, however, countervailing circumstances that the court may consider relevant to the issue above. 8. Firstly, already suffered prejudice. Moreover, 9. Moreover, in any event, the time for removing the appellant under the terms of the Dublin regulation had expired. So that's why this all cropped up as a result of this new point about the expiry of the window for removing somebody cropped up because of this. And then 13, as the appellant understands the respondent's position, it is no longer disputed that the appellant is entitled to substantial damages for his unlawful detention. Apologies for doing this slightly out of order, because in fact, at paragraph 9, what is being submitted on behalf of the claimant, we'll just call the claimant for these purposes, was, look, let's be pragmatic about this. We're now in the COVID-19 pandemic. If you're going to have a disputed age assessment, it's going to be very difficult to do. You can't do that remotely. You know, can we be pragmatic and just sort of sort this out? And at 14, then, the position was taking the matters above into consideration. Therefore, the reasons underpinning the parties' inclusion of remittal to the UT for determination of draft order are potentially no longer quite so compelling. Should the respondent, i.e. the Secretary of State here, agree to consider the appellant's substantive asylum claim in the UK, his damages claim can proceed in the county court as default of agreement. If not, the appellant is content for the matter to be remitted as agreed, although the respondent's position on this may be relevant to any future assessment of costs. So my point about this document is that the position, certainly on behalf of my client at the stage before Lord Justice Dingemans, was, look, is there a way to be pragmatic about this? If you send it back, there's all going to be delay because you can't have a contested hearing. There are other points, because of COVID pandemic, there are other points now that arise, namely that in fact the window for removal has closed in any event. You know, what should happen? But the Secretary of State obviously didn't want to come to that view, and so the matter was then remitted on two bases. One for the window, has the window now expired? Question to go back. And secondly, depending on the outcome of that, whether or not to have a substantive age assessment. So the chronology is relevant because it shows you that this is not a case where the claimant can be said to be guilty of the sorts of things that have been pointed out in other cases, of having a totally unmeritorious claim, for example, which is the cases in ZN and KA, and also for the Malta claimants in Testify, of lying to the court about various things. Again, that was the case of the Malta claimants in Testify, of dragging their heels or behaving in some sort of way that the Secretary of State, you know, is concerned that everybody, that the claimant dragged out the proceedings. They didn't. And so I just wanted to show you that context. And the final point on the chronology is, of course, that the hearing that was agreed to happen about the age assessment, which was due to occur on the 3rd, 4th and 5th of July 2018. Now, we know what happened, that Judge Coker raised a different view as to whether or not she had jurisdiction to do it, and that the Secretary of State then completely reversed her position and supported her in that. And the Secretary of State says we shouldn't be blamed for it. But stopping for a moment, the appeal was filed on the 2nd of August 2018. And the Secretary of State could then have looked at that appeal and said, yeah, they're right. And then the matter could have been the subject of a consent order much earlier than when it was. But instead, the Secretary of State waited until after permission was granted, permission to appeal was granted by Lord Justice Hickinbottom in 2019. And then came to the position that she did, that the whole matter had to be remitted. And
Could
so,
you just help me where in your argument these submissions are going to feature?
they're going to feature in the question of success and conduct.
Right.
Right, so that's all I wanted to say just about the outline factual framework, if you'll permit me. So then, turning then very shortly to the principles that apply in a cost appeal, very shortly, we submit that it's trite law, as held, for example, in M against Croydon, as the first general principle, that any decision relating to costs is primarily a matter for the discretion of the trial judge, which means that an appellate court should normally be very slow to interfere with any decision on costs. That's paragraph 44 of M, dealing with the general principles. M is tab 9, I think. Yes, M and Croydon, tab 9, paragraph 44, which is at page 107. And the paragraph goes on, of course, while why the discretion must be exercised rationally in accordance with certain generally accepted principles. That's obviously entirely accepted. The question of costs is both highly fact sensitive and very much a matter of the discretion of the first instance tribunal. That's at paragraph 1 of the same decision. Then turning to a separate authority, and that will be the only one that I refer to on this point in addition, is the case of Roach against Associated Newspapers, which is at tab 6, Authorities Bundle, page 58. Sorry, it was against Roach against News Group, not Associated Newspapers. And this is, of course, a civil claim, not a public law claim. But Lord Justice Stuart Smith states in the middle of the page, this being an appeal on cost with the leave of the judge, the ordinary rules as to review of the judge's discretion apply. The court must not be tempted to interfere with the judge's order merely because we would have exercised the discretion differently from the way in which the judge did. Before the court can interfere, it must be shown the judge has either erred in principle, his approach, or left out matters taken into account, or taken into account some feature he should or should not have considered. Or that his decision is wholly wrong because the court is forced to the conclusion he's not balanced with various factors. And there are similar statements in other cases. And so the Secretary of State must show an error of law in Upper Tribunal Judges O'Callaghan's experienced and we say careful judgment, and must do so in light of the submissions that were made to him, which in fact were different from what submissions have been on this appeal. So turning then to the third heading, which is whether Upper Tribunal Judge O'Callaghan made an error of law. In my submission, we need to start with two basic principles which are worth reminding ourselves. The first is that the discretion to award costs set out in the CPR Rule 44.2.2 is a broad one, and the general rule is that the unsuccessful party will be ordered to pay costs, but the court may make a different order. Now, you've got a version of the CPR in the authorities bundle, but it is a bit odd, and I don't think it's the right one. So if you could just turn up Testify, which is tab 10, page 122. At the bottom of the page, entry G. the provisions are set out there. The Secretary of State's argument is predicated, we submit, on the basis that the claimant obtained his relief of stopping his removal to Finland as a result of extraneous matters that have no connection with the claim that he brought, and that accordingly his decision is unlawful. But in my submission, one actually needs to go one step back and go back to the concept of success. What is success in proceedings? And I have two overarching points that I'm going to make about that. The first is that in considering whether there is success, consideration of the litigation as a whole is relevant. And the second point is that there is an element of judgment and discretion in considering what amounts to success in any individual case. And it will follow, I will submit, that the approach of the judge below was properly open to him and within his discretion, and this court should not interfere. Now, I'm going to seek to make those propositions good by reference to three cases. They are Tesfaye, ZN and Patel.
I don't want to interrupt this very helpful exercise, but it is right that this was absolutely not the way it was put before the judge on paper.
Yes.
Where success was identified by reference to having his asylum claim considered in the United Kingdom. The claim, my point about how the case was not argued in the same way to the judge was by the respondent. Yeah, I know, and I'm now putting the same back to you, because if we look at the written cost submissions,
yes,
the only submission made, the focus in determining whether the applicant, that's your client, succeeded is whether he has achieved what he sought in his claim. The
yes.
applicant who is having his asylum claim considered in the United Kingdom has on any view succeeded.
Yes, that's how it was put, yes.
And as I understand where you're going with this, correct me if I'm wrong, is you're saying that presumably, well, is it part of your central primary resistance to the appeal, or is it part of your alternative case under your under sort of the general suggestion that we should remit or decide this anew for ourselves under some sort of rehearing, that we should take a broader approach to the question of success?
No, my primary case is that success as we defined it was within the scope of what the judge was allowed to decide, and so he made no error of law. But if I'm wrong about that, then my respondent's notice is relevant, which is, okay, we'll look at success in the context of, look at the conduct of the parties overall.
I mean, he found success by reference on the narrow basis that was advanced to him, paragraph 24 of
Yes.
his decision. He was not looking at success on any broader basis, was he?
He was not looking at success by taking into account conduct of the parties, no.
Sorry, you were going to go to the authorities.
Thank you, my lady. Yes, Tesfaye. So that's at tab 10. It starts at page 106. You can see from the head note that there were 9 cases. In fact, the court, which was Lord Justice Lloyd Jones, as he then was, who gave the main judgment. That starts at page 121, and there was, as you can see from the first paragraph, there were a lot of applications a lot of cases following the decision of the Supreme Court in EM Eritrea. And there were 9 cases in front of the court, which the court grouped into 2 groups. One group was known as the Italy claimants, and the second group was referred to as the Malta claimants. In the judgment, you first know the third group, but that's because there were 2 Italy claimant groups. In the Italy claimants groups, the individuals had put forward arguments that were substantially the same as the ones that ultimately succeeded by different claimants in the Supreme Court. Just one moment.
What, in EM Eritrea?
Yes.
So that's all, is that Italian prison conditions? All like that, wasn't it?
I don't think so.
Doesn't matter, don't distract, that's fine. But
I
anyway,
don't think
I've
it
got the
matters.
point.
Let me just find the question. Sorry, I can't find the reference for something that I've written out. Could you just bear with me one moment? Which is where the court frames the question, which he says was the effect of the withdrawal of certification of the human rights claims that the claimants should be regarded as having succeeded so that they should receive their costs, or was there good reason to make a different order? And I'm just looking for the reference for the... Sorry?
86.
Paragraph 56, my tune's helpfully telling me. No. Oh yes, that's right. It is paragraph 56 on page 100. Starts on page 138. So at paragraph 56, the court sets out what the questions were, because in all these cases, the individuals had not got their costs. At paragraph 57 is the key point. At the heart of this dispute as to cost lies the question of what should be considered a success in public law litigation. Whereas in a settlement in private law litigation, it is usually possible to identify with some precision the extent to which a party has been vindicated. Position following compromise in public law litigation is often not so clear-cut. And then at the bottom of the page, success in public law proceedings must be assessed not only by reference to what was sought, the basis on which it was sought and on which it was opposed, but also by reference to what was achievable. The court then goes on at paragraph 66, dealing with the Italy cases. While the claimants in the case now before us have never obtained permission to apply for judicial review, other claims raising the same points did, and those other claims were successful. It was a matter of timing as to which claims went forward. That's your point, my lady, at Whipple's point, and that relates to the Italy cases. Paragraph 67. In public law litigation, securing reconsideration of a decision which is challenged is usually considered a success for cost purposes. Alternatively, right, no, that's fine. In my view, paragraph 68, the withdrawal of the human rights certifications which occurred in the present case should be equally regarded as a success for cost purposes. Considering the matter in the round, claimants were vindicated in the proceedings in the following respects. Their position on legal issues was accepted by the Supreme Court in Eritrea. They obtained repeated stays on the removal and the certifications of their human rights claims were withdrawn. Applying the approach laid down by this court in M. and Croydon, they should be awarded their costs in the absence of good reasons to the contrary. So that was the position in relation to this. Now, obviously, in those cases, the legal issue had been determined in a different case. So I see that that is different from my case. But going then to the Maltese cases, by contrast, the court deals with that. You don't need to read all the procedural history. Paragraph 100 starts at paragraph 110. Now, there were some other procedural shenanigans within that case, and at 110, the court does not accept that some argument they were now running in the Court of Appeal was a key aspect or a main plank of the case before Mittingay, which they had lost. That's at F. And at the bottom of paragraph 110, the court says, in my view, it's clear that the claimants were seeking to advance a new claim before the Court of Appeal. And paragraph 112, it can be said that, in one sense, these claimants were successful in their proceedings. They brought a challenge to the certification of their human rights claim, and those certifications were withdrawn. While it is right to point out that they sought to persuade Mittingay that he should conclude that their human rights claims were not so clear without substance that an appeal was bound to fail, there was never any realistic prospect that the court would do more than quash the decisions and order reconsideration by the Secretary of State. To this extent, therefore, the position of the Malta claimants can be compared with that of the Italy claimants. However, paragraph 113, the similarity ends. Italy claimants had raised at the outset arguments of law which was opposed and which eventually upheld. By contrast, in between letters F and G, at the date of the withdrawal of the certifications of the Malta cases, the claimant's case had been comprehensively rejected at first instance, and the Court of Appeal had refused leave to appeal against those decisions. The only point remaining to them was whether they should be permitted to appeal on a new legal basis, which they had not relied on below. When the withdrawal of the human rights certification of the Malta case is viewed in the context of the proceedings as a whole, the degree of success achieved was distinctly limited. In any event, paragraph 114, I consider that there are here strong reasons which justify the denial of the claimant's claim for costs. First, the Malta claimants had given false accounts. Secondly, the case law did not cast any doubt on the correctness of the decision of Mr. Justice Mitting. And thirdly, by the time the certifications were withdrawn, the claimants were reduced to seeking to take the new point which had not been taken below. What I submit you draw from this is that success is fact sensitive and needs to be looked at in the context of what was sought and what was achieved. And that actually, in my submission, one can take a relatively broad brush approach to what is success, or rather that is a matter of assessment of the judge. The second case is ZN, which is a case specifically about this type of certificate. That is at tab, it's page 170, but tab
11.
11. Thank you, my lady. This is a judgment of Lord Justice Singh, which I think has already been mentioned. And you can see by way of his introduction at page 159, paragraph 1, that the court was put together to consider some issues of point of principle. And the case arose in paragraph 2 from transfers under Dublin 3, or certificates made under Dublin 3. That's the bottom of page 159, top of page 160. And there were two appellants, ZN, who was an Afghan national, and his removal was going to be to Bulgaria. You see that at paragraph 4. And he was running a case that Bulgaria was not a safe third country. The other case was, and his case, in fact, that permission to apply for judicial review was refused, and the case was certified as totally without merit. That's paragraph 14. And paragraph 15, you can see the administrative error that happened in that case, and it was to do with time limits and windows of transfer. That's paragraph 15. And then on the 18th of April 2016, so in fact after the transfer window had closed, Court of Appeal granted permission to appeal, but in fact by then the Secretary of State took the view that she could no longer remove him. So the certificate was withdrawn, and the question was that success? It was similar in the case of KA, although there wasn't a wrong calculation, it's just that the window had continued to run and the clock had run out. So that's paragraphs 27 to 30. Mr. Nafla QC submitted they'd been successful and should get their costs, but paragraph 66 the court, perhaps understandably, balked at that suggestion in circumstances where it says, if the appeals had proceeded to be determined on their merits, there can be no doubt that they would have been dismissed. In my view, the appellants cannot be regarded as having been successful. I'm supported in that view by the reasoning of the court in Test 5, and in particular by way of analogy with the Malta applicants in that case. And then it goes on to say the underlying rationale for the normal rule that costs follow the event is that the party has been compelled by the conduct of the other party to come to court in order to vindicate his legal rights. If those legal rights had been respected in the first place by the other party, it should never have been necessary to come to court. Accordingly, there will normally be a causal link between the fact that the costs have been incurred and the underlying merits of the legal claim. And then there's the exchange, which I know you've been asked to read already and I won't read out. But the exchange recorded at 68 through to 70 is that the court rejects or suggests that that where there's no causal link at all between the reason why the appeal is ended with an outcome and the fact that the costs were incurred, and says at 69 in response to Mr. Nafla's submission at the bottom of page 170, Mr. Nafla submit the present case as distinguishable because the reasons why the appeals become academic is not for some entirely extrinsic reason but arises from the conduct of the respondent. And the court says the answer to that submission is what the CPR rule is normally concerned with, is the conduct of a party in the litigation itself, not some other conduct. And so, and that would explain also why a default judgment is, if a default judgment is obtained, somebody may well have a fantastic defence of the claim, but if they don't actually file it, then it's their conduct, and so the costs follow the event. Finally, there's the case of Patel, please, which is at tab 13. Which is another case involving costs in the immigration context. This was not a Dublin third country case, but actually it was one of the cases, cost cases, that arose out of the widespread cheating that was discovered when people were taking their English language tests some years ago, in which individuals were having proxy test takers so they would then pass it. And as a result, the Secretary of State curtailed or cancelled a lot of people's leave, believing that they had obtained that leave by deception, having used a proxy test taker. And one of these individuals, this is the case of one of them, brought a claim for judicial review, challenging that decision and seeking, by way of relief, the determination that she had not used deception, in fact. And the answer at paragraph, in analysing the case, page 203, Lord Justice Hickenbottom said at paragraph 20, where there has been no determination on the merits, then Lord Neuberger in M identifies three general categories of claim. First, where the claim has been wholly successful, i.e. has in substance achieved what he set out to achieve, the claimant should generally be entitled to his costs, and then sets out the other categories. 21, it is well established that the question of who is the successful party for CPR purposes requires a fact-specific evaluation by reference to the litigation as a whole, CEG, Custer Navigation Company, and it has to be considered in the context of the real world. Thus, in Bank of Credit and Commerce International, Lightman J said that, for the purpose of the CPR, success is not a technical term but a result in real life, and the question as to who has succeeded is a matter for the exercise of common sense. And in that case, Lord Justice Hickenbottom refused the costs of, for the individual because she had not succeeded in what she set out to achieve, namely a finding by that court that she'd not used deception, but rather what she had achieved was an in-country right of appeal where that question was going to be determined. So she was partially successful, and the appropriate order was no orders to cross. Now, in my submission, it's understandable that in those cases that the courts found there was no success. There was a well-trodden path demonstrating demonstrating failure of the arguments, despite some relief in the case of Patel, or all the relief in the cases of Tesfaye and ZM being obtained. In our case, there were no failures. On the contrary, the claimant succeeded in obtaining written acceptance that the basis for the decision to treat the claimant as an adult was flawed and in breach of policy. That was the consent order that I showed you. The question of the claimant's age, which remained important back in 2018, should have been resolved in July 2018, but wasn't, because the Upper Tribunal judge took the view a different approach was required, and the Secretary of State encouraged her in that view. And so we are in a situation where the original issue as to age could have been determined in July 2018, but wasn't. Now, obviously, Judge Coker was an independent person, not under anybody's control, but it's got to be a reasonable prospect that she may not have taken this approach if the Secretary of State had not encouraged her in it. And as a result of the additional delay, a further point arose on the question of transfer windows. Now, so we say on real-world success, the claimant has achieved that success because the aim being to have his claim determined in the United Kingdom, which is what happened. And stepping back, we submit, one can see how it was totally appropriate for Judge O'Callaghan to take a broad brush approach to the question of success, and that approach was entirely within his discretion.
The difficulty with that is that this court has considered exactly this situation and has said it's not success.
But it hasn't.
Well,
It hasn't.
that seems to be the key question. How do you distinguish MH Eritrea?
That's not difficult. MH Eritrea does not take the matter any further for a number of reasons. The questions in MH Eritrea were different to the questions that were being asked by Judge O'Callaghan. Questions in MH Eritrea was one, is the appeal academic? That's page 238 at F. And the second question was, should the court nevertheless consider the merits of the appeal in order to make a decision on costs? Now, paragraphs 42 to 44, which you've been taken to, and we can go back to them, are in my submission a compressed summary of general principles, but are not intended in any way to undermine the nuanced approach exercised in those cases, which this one cites, which shows that that it is indeed fact sensitive. And the striking thing, and the thing that makes the case law actually rather burdensome to read, is that the procedures that were being applied, the history of the case, is very important because it's entirely fact sensitive. And the final point of distinction in MH Eritrea is that he had lost. He had had a substantive determination of his legal point before the judge below, which I think was it.
Justice Murray, and so he was appealing that.
Yeah, exactly. So in a sense, the context is wholly different. So all the cases where the claimant achieves an outcome, which on the face of it is what they set out to achieve, if they don't get their costs, it's because their underlying cases were hopeless or had failed, which is the case in the Maltese applicants, it's the case in ZN and KA, and it's the case in MH Eritrea as well.
That's where the tolerably clear debate comes in. So you're quite right here. There's been no finding that's hopeless.
No.
What level of finding is required in order to be judged successful?
But what my submission is that actually success, you can just say, right, well, there's been no determination of the substantive points, setting aside the point about tolerably clear. And my primary submission is you don't need to go there in circumstances where you have conducted your litigation reasonably, a finding that's been made, and you've achieved the outcome, and there are no points that can be taken against you, which is effectively
but that
how
doesn't address the analysis in MH. There's some that we've compressed or not. The analysis is there's no causal link between the outcome and the merits. But
there is a causal link in this case because the proceedings had to be brought to deal with the original unlawful age assessment that was held to be lawful. So they had to be brought. They succeeded in stopping removal at the time, which was entirely correct. They've succeeded in getting unlawful damages or unlawful detention damage. I accept that those costs have already been highlighted.
Correct.
That's fine.
I mean, that's a very important bit, I think, in the chronology, because it does look to me, I could be wrong, that the costs order made upon the compromise of what had been, as it were, conceded was dealt with in that costs order. You got all your costs, you got your damages, and you got your costs. And you almost draw a line in the sand, and then you deal with what's left. And we're dealing with the costs of what's left.
Yes, I mean, I think there might be scope for differing views as to how far across the line in the sand goes, because I entirely accept that the costs relating to the unlawful detention aspect have been dealt with.
That's the meter order, and that's very clear, isn't
and
it?
that's completely clear. But of course, the claim. And if you look at the claim consisted of several parts: the unlawful detention aspect, but also the certification aspect. And so, some of the costs that can be attributed of the claim to the unlawful damages will be in the unlawful damages pot, but it still leaves those parts of the cost that are not attributable to unlawful damages, not properly attributable to unlawful damages, still at large, and those costs were reserved.
And then there's been some more since.
And then there's been the cost since. And
the cost order of Judge Callahan deal with the reserve costs.
my understanding is that the point about his order was he was to deal with all of it, everything that was at large at that point. If you look at the terms of the consent order in the Court of Appeal.
Did he know that there'd been a reserved order at an earlier stage? I hadn't picked that up from the submissions.
Let me just, if you just give me a moment. Sure. So, if it goes to the Court of Appeal order of Lord Justice Dingerman's, page 40.
38 is the cost order.
Thank
Supplementary
you.
bundle, page 38.
Thank you.
Cost.
Yeah.
Thank you.
Paragraph.
So the 15th of April order 2020 from Lord Justice Dingerman's, it sets out a statement of reasons. So orders at 5 on page 36, paragraph 5. The respondent shall pay the appellant's reasonable cost of the hearing on 3rd and 4th July 2018.
Is that the COCA hearing?
Yes.
So that was the abandoned age assessment, which you say was erroneously abandoned, that one.
Yes.
So you've got your costs back on that.
So we've got the cost of the hearing.
Yeah.
And of this appeal, so we've got the costs of the appeal, to be assessed on the standard basis, if not agreed. Costs in respect to the judicial review proceedings are otherwise reserved to the Upper Tribunal. So and because he sets out in the statement of reasons which follows the whole of the order from 2018, it must be surely, my respectful submission, he was mopping up whatever was left from the
Everything
earlier
now is back in the
order. Yes.
in the Upper Tribunal.
So that's what then went back to the Upper Tribunal. So
The order actually made doesn't say the applicant's costs or what. Just say the respondent is to pay the applicant's costs.
Which order is that?
The one under appeal at page 100 of bundle. Core bundle.
the core bundle.
But your submission is it's everything that was left. So it was
Yes.
not. So it was the JR costs with the time limit hearing costs most of it, wasn't it? Because anything unlawful detention had been mopped up and dealt with.
The unlawful detention had been mocked up and dealt with. The costs associated with the abandoned appeal, it seems to me is the correct reading of this, are also dealt with.
Yes, that's true.
I mean, there may...
Couldn't be the time limit point because that wasn't raised till April 2020.
No, but it also couldn't be raised until April 2020. It only became relevant because of the procedural history at that point. So that was raised in April 2020 in the context, of course. And I realise that I'm straying slightly into my merits point as opposed to. I realise that, but it's easier to tell you where we stand overall. It is that. Yes, and then the costs relating to the hearing in September, October 2020. So then just going back to, so did the judge in some ways misunderstand or misdirect himself?
Coming to the absolute key
Yes.
point now, I'm not sure how long you're going to be over this, but it's
Oh yes, I apologise.
just gone 1 o'clock.
Yes, I kept an eye
If
on
it's sensible for you to finish it now, whilst you're, but it seems to me this is rather key, and maybe we should pick it up again at 2 o'clock.
Could we pick it up at 2 o'clock?
Yes, of course.
Thank you.
Thank you very much.